Hey, we want to welcome everyone to You and the Law podcast show. We've got another another episode of podcast show that's going to be a great topic where we're going to be talking with some guests that we've had on before. They are supporters of Michael Gaines, and so we're going to bring these two ladies podcast show and be a part two of the Michael Gaines case that we had them on a couple weeks ago. We had a lot of good response from those who know, and there's some things that have since the podcast that real for Mr. Gaines' case, and other people are going to be getting involved with it, and because it's a story that needs to be told. A lot of people that's concerned about how to play, and he got convicted serving a life role. So I'm going to bring on our guest tonight, and guest her name is Bree, and the other guest is Melissa. So let me, Melissa. So how you doing?
I'm doing well. How are you?
Doing great. Good to see you.
You as well. Thanks.
All right. We've got Bree. How you doing? Hello, Bree. Well,
can you hear me?
Yeah, I can hear you.
Okay. How are you?
Right. Okay, I'm doing good. And let's bring on my co-host of the show, who goes by the name of Chief Swag. He is doing this also. So glad you ladies have been able to part two of the Michael Gaines. There's been some positive things have happened since our last podcast. So we want to talk about that, and hopefully this will just bring a little bit more awareness to his case.
Wonderful.
All right, great. So when we had you ladies on before, we kind of talked a lot about how he was represented, his public defender.
Yes.
And since then, I've looked into some things as well, and people don't fully understand how that process of the criminal justice system works, where a person is appointed a public defender if they cannot afford one. And so, we obviously, it appears that he was not adequately represented during his trial. But Bree, one of the things that you had brought up earlier was the fact that prior to him being arraigned, he had an attorney that was with him prior to one of his prelim hearings. Is that correct? I don't know. Can you hear me, Melissa?
I can hear you. Yeah.
Okay. So are you familiar with the attorney who appeared with Michael, but I believe the police basically said that she was not an attorney that they were aware of?
Can you hear me?
Yeah, I hear you, Bree. Yeah.
Okay. Sorry, I don't know if I cut out or not. At the time, Lisa Patel came on with him. When they found out there was a warrant issued, they ended up, Lisa knew his family. She and his mother asked her, could you go with him? Because Michael was under the impression that I've been set up, I've been framed, so we're just going to go in, let them know that I didn't do anything, and they were going to come home. Lisa came with him. Well, when that happened, they notified Lisa that you're not retained for this case. I don't know how they knew if she was or wasn't retained, but they did not go back with him for questioning. They would only allow her to appear for his arraignment.
So, stated that they would only allow to be there just on the arraignment. They did not allow her to be a part of any question.
That is correct.
All right. I'll just say, ladies, my co-host, are you in? Can you hear? Okay. All right. Make sure that we can hear each other. So, one of the things, everybody has the opportunity to have counsel represented with them prior to, if the police wants to question you. Now, if you're being told that you don't want to question, if you don't want to talk to the police without an attorney, then that is something that obviously that's your right. And so apparently it appears that what you all are saying is that the detectives involved in this case in Lawton did not allow him to have an attorney present with him.
That is correct.
Okay.
He was able to only, like I said, now we're not understanding why she was okay for arraignment, but she wasn't okay for questioning. Even after the arraignment, the detective came over and told him that he wanted to question him. He said, Michael stated, no, I don't want to talk because my lawyer told me not to. And he said, I looked and I see that you don't have anybody retained at this time. So I'm going to read you your rights and we're going to take you over for questioning.
So let me ask you this. Has anybody ever spoke to this attorney and to see what happened, why she wasn't allowed to be a part of the questioning?
I tried to find her, but she obviously isn't practicing anymore because the number that I have is disconnected. So I have no way of reaching her. And even the family doesn't have a way of reaching her either. So I'm not sure if she's moved or, I don't know what's going on with her.
Okay. All right. So Melissa, last time we had you on, you were very knowledgeable about what is going on with the criminal justice system, how defendants are represented in court or not being represented in court. With your involvement in it, what are some of the things that you have done in regard that's related to how his public defender represented his case?
Well, I'm very interested and I study regularly how wrongful convictions happen. So right now, I'm actually studying life without parole sentences in wrongful convictions. So you can compare a life without parole sentence to the death penalty for the fact that they're actually, sentencing you to die in prison. So I have a concern with once you're sentenced to life without parole, and now, I fully believe they coerced Michael into pleading out to life without parole, which makes it even worse.
Yeah.
But, they use those intimidation tactics in these cases. And, I'm not saying it happens in every case. Obviously it doesn't, but we have to look at the fact that official misconduct, which includes law enforcement and prosecutorial misconduct, has occurred in over half of all these wrongful convictions. So, we've had a little over 3,000 exonerations since '89. and 54% of those included official misconduct. So we can't turn a blind eye to that. And the fact that a life without parole sentence, once you are in there and you're sentenced to life without parole, you got no continuous representation. You have there's all 49 states practice life without parole. That's the sentencing option in 49 states, but only 11 of those states have any guidelines for these attorneys who are representing serious felonies, murder charges.
Okay.
So the lack of effective representation is huge, and we could see that in Michael's case.
Yeah. So for those who are just now tuning into the podcast show, we're talking about, this is part 2 of the Michael Gaines case, where Michael Gaines was convicted in 2003 in Lawton, Oklahoma, where a murder took place. And you ladies know a little bit more about it, so I'll let you, either one of you, Melissa or Bree, kind of give a little bit more background about how this case came about.
So Michael was riding with 2 gentlemen who actually had already premeditated to commit this robbery. And with doing so, they took advantage of Michael and another guy that was a co-defendant by giving them weed with PCP on it and gave it to them to take control of the situation. And once Michael and the other gentleman were high, and they gave them alcohol, they utilized Michael to only knock on the door at the apartment where the robbery was going to take place. Once Michael did that, the other 2 co-defendants ran in and committed the robbery, and then the shooting took place. And they, of course, unfortunately, someone lost their life behind that. And everything kind of spiraled out of control. Daniel Moore, who was the person that was responsible for the part of that shooting, his lawyer advised him to put the blame on Michael, basically, because if not, then he would be the one facing the death penalty, which is what they used. They utilized using the death penalty as a tool to get them to do exactly what they wanted them to do. So at that point, they had Daniel, Deontay, and Timothy in custody. And once that happened, they were able to let Deontay and Daniel, who were the 2 that put this together, solicited the crime, executed the plan, they let them have a cell together where they were able to get a story together and utilize that to their advantage so that they could get a plea deal, which they did. They got a 20-year plea deal for just robbery, and where Michael and the other gentleman got felony murder.
Okay. So the other 2 defendants, how many years did they serve?
I'm going to say probably right at 17 because they're both home now.
Okay.
They got out, I want to say they got out in 2020.
Okay. And the actual person who committed the crime, he is serving a life sentence in prison as well.
Yeah, he is serving a life without parole.
Okay. Okay. All right.
Michael and the other guy that did the actual shooting, they both were only 18 at the time when this happened, where the 2 who perpetrated and put it together, one was 27 and the other was 22.
Okay. And so Michael was the youngest out of all of the defendants involved in this case. Is that correct?
I do believe so. Yeah. And so Daniel felt that if he put it on Michael, from his understanding is that Michael wouldn't get in as much trouble because he was the youngest one out of the situation, but he was 22 and he had already been in trouble before. So he didn't want to get in any more trouble. So he was like, we'll just put it on Michael. And that's what he says that his lawyer advised him to do.
So this is what one of the defendants' attorney advised him to do?
That is correct.
Okay.
In order to keep from getting the death penalty is what they stated, then he needed to find someone else to put the story on. And that's when he turned the finger on Michael.
Okay. So the other 2 defendants, did they have private attorneys or were they represented by a public defender?
No, they had private attorneys.
So did they both have separate attorneys or did they have the same attorneys? Do you all know?
No, they had separate attorneys.
Okay. So their families were able to afford to pay for them and attorneys. Is that correct?
Mhm. That is correct.
Okay. So, like, we've got a question with one of the person that's watched us on Facebook. That's Joy, who says, "Has Michael been on DR?" I'm not quite sure what.
I think that's death row. I think that's death
Oh,
row.
death row. Okay. All right. Yeah. So,
And to answer that, no, he has not been on death row, but they utilized that to get Michael to plea in the direction that they wanted him to plea. They told him that he is pleading guilty. What they actually told him is that he would plead guilty to a robbery and get a 20-year sentence. And that's what Michael ended up agreeing to plea to. And once they said, so when he walks in to plea, the judge says, "I understand you're coming in today to plead guilty to a robbery to prevent the death penalty." And that's when they proceeded to railroad Michael and let him know that a murder happened during the robbery and that he was responsible for that. So they pretty much gave him what they felt was the lesser of the harsher sentences by giving him a life without parole.
okay. And one of the things that, we've seen that happen in the criminal justice system, especially when someone, whether they be a juvenile or they're, 18 years old or 20, where people will feel that they may receive a lesser sentence for the crime that they have committed. Chief Humphrey, he can, speak on to that as well, that oftentimes you find older people who commit these crimes, but they have juveniles with them who take part in these crimes, and they let the juveniles commit the crime because they know that, they won't receive a very harsh sentence at all.
Yeah, I think and good evening, Melissa.
Hello.
And I can't see our other guests, but good
Yeah,
evening.
Bree. Yeah, Bree. We can't see Bree, but she's there.
Good evening to you all. Good evening to you also. So I know that early in my career, that was the case where you would have adults that would have juveniles commit crimes because they felt as though the juveniles would not, and that was true. I'm not sure a lot of the ones who are committing these crimes now, especially adults that try to do that, I don't think they understand the juvenile law. But they don't understand the laws. Let me get back to Michael. Has an appeal been heard, or is there appeal pending?
He did try to help himself when he found out that he had been involuntarily drugged with PCP. He did try to start a post conviction, but it was denied. So he decided to stop and try to gather more information to help himself with trying to proceed forward with that.
So pretty much he has exhausted his appeal process that is afforded to those who've been convicted of a crime. Is that correct?
Yes, unless he comes up with additional new information that he could use to raise another concern in his case.
Okay.
How old is Michael? How old is Michael now?
He's 37.
So he's been in almost 20 years.
Yeah,
Yes.
over 23 years. Yeah.
That is. How's he doing? I mean, how often do you all get a chance to talk to him, visit with him?
I do communicate with him as much as I can, and he is doing well. I will say he does have a fairly good spirit about hoping that he can get some kind of justice for what has happened for him. He does know that he's innocent and that he did not commit this crime. So he's really just hoping that the system actually will work in his favor and actually correct the wrong that took place.
So how do you get that? I've spoken before on young men that I've spoken with that have been exonerated. Some 10 years, and some as many as 35 years they spent. How how does Michael, when Michael gets his appeal and we're going to claim it when he wins his appeal or his second attempt, how does he get his life back? I mean, how do you correct that? How do you get back to normal? Or is there a normal?
I believe that he would have to adjust to what I think would be a new normal for him, because all the years of him learning, trades, making mistakes, continuing school, which I mean, he could still continue school after he were to get out. I mean, he does have I guess we'll call it like an associate's. He took a computer programming business class while being incarcerated, and he got to graduate from that. So, I mean, he does have some kind of skill he could use to, get him out when he leaves the world or into the world. But he does have a family member that lives in Texas, and he does have a business, and so he would be able to work with him. That is something that he does have an advantage to.
So we have a question from one of our listeners on Facebook.
George.
Harvey is asking, can he prove that the other guys set this up?
I would want to say yes, he can prove that just through some of the statements that we have been able to get our hands onto. I mean, in one of the statements, it states that Daniel actually threw away a gun. He saw the police that night, and he actually threw the gun away that he used. They just have never been able to retrieve it. And I believe that through statements and actually being able to talk to people again, that he would be able to prove that also, because no one actually at this crime actually knows Michael. He was he was actually there, but the finger was pointed at him for committing his part in that, which was really Daniel's part. And I do believe that Michael would be able to get it cleared if his lawyer wouldn't have waived his preliminary hearing. I do believe that all this information could have come out, and they would have seen that Michael couldn't have had any part in committing this crime.
Okay. So we've got another question from another viewer. Joy Hartman Robertson asked, did Michael know the victim?
He did not know him on a personal level at all. Lawton is a small town. Maybe he had seen him or whatnot, but on a personal level, Michael did not know the victim. Michael didn't know where the victim lived. Michael didn't even know the victim's best friend, whose apartment was robbed. Michael didn't know anything about those guys. He literally got into the car with someone he knew and thought they were just going to hang out for the day, which that completely turned into a nightmare and changed his life forever.
Okay. So, Melissa, let me ask you this question. With Michael having exhausted his appeals, is there anything that you have came across that's potentially new evidence that, I know you're not an attorney, but
No.
Is there anything that has stuck out to you that potentially can get Michael back into the courtroom based upon some new evidence or some new information about his case that took place in 2003?
Well, so we have the issues of, like Bree just mentioned, the statements. We have the issue of his ineffective counsel, and I think that what it would hinge upon would be to, like Bree just said, obtain statements from the people who were involved. That would be the most beneficial for Michael. That would be in my opinion, that would be the new evidence to bring, before the court. Mm-hmm. It's even difficult in that regard sometimes too, because the same witnesses that the court would believe, 20 years ago, if they come back and have a different story, then all of a sudden they become not credible. That's happened many times.
Yeah.
So, that's even difficult. But I think, in my opinion, if you have somebody who knows what happened and said something and somebody else corroborates it, I think that is where you really need to try to tie that together. But short of that, I'm not sure. Even we know that the counsel is ineffective, but the court doesn't like to recognize that very often. So and I do know that there are, since
our last podcast show, several people have reached out to Bree, and several people have also reached out to me. One of those being Sarah Banner, who is working to put a group of people together who are activists, who they know a lot more about this side of things than we do, or than me and Chief Humphrey do. And so hopefully Sarah and her group can help you all in lead into a direction that hopefully an attorney can look at this. And if an attorney can look at it, obviously that's going to help a lot, where maybe there's some hope that some things can be brought back into the courtroom.
Yeah, the more attention you bring to a case like Michael's, of course, the more beneficial it is. People start paying attention to the injustice, and that's where advocacy comes in and works too, at the same time. So
let me ask you this. I know we're getting close, but how does the criminal? I mean, if the criminal justice system is supposed to be fair, and I get it, you have a lot of people that say they're innocent. What is that saying? Everybody that's incarcerated is innocent, that based on their own saying. But I go and I want to know, with everything that you're revealing here, it seems that Michael deserves an appeal. With the criminal justice system, we talk about Lady Justice is balanced. Why is it difficult for him to get an appeal? I hear people say that they have a difficult time getting appeals. Why is it so difficult for a person to get an appeal? Why is it that judges have the right to automatically say, I'm not going to hear that, I'm not going to give you the rights to appeal? I mean, how is that fair? I guess that's my question.
Well, I think in a lot of even cases that do go to trial, appeals are not, they don't. So if there was evidence available and it wasn't presented, then you're procedurally barred from rebringing that evidence. So they're not going to consider, evidence that they think was, I know Michael's case didn't go to trial, but even in a case that does go to trial, if you don't bring that evidence at the time of trial, if you have counsel that's so ineffective that doesn't bring up evidence that really could, find you innocent, then you're barred because of the AEDPA. You're barred from bringing that evidence again. So an appeal is only if there was an error in law. So they're not going to say, well, it looks like there's questions of innocence in this case. They don't do that. It doesn't work that way. So when people say there's all these processes to make sure somebody's not wrongfully convicted, there's all these processes, but they're very rarely successful. And so that's where the problems are. A habeas writ was supposed to be the great protector from people being wrongfully convicted. But when they passed the AEDPA in 1996, that kind of did away with that, because now you got one shot basically, and that's your trial. And if you can't come up with any new evidence that wasn't available at trial after that, then there's nothing that you really can do. That you're procedurally barred from bringing anything that could have been brought up at trial.
Yeah, exactly.
Or even before conviction.
Yeah. Hey, we've got another question. The question is, was the bill filed for the DP?
Death penalty.
Death penalty. Okay.
No, they never actually filed a bill of particular at all. They actually just used the death penalty as a torture for Michael to actually plead guilty to what I continue to say was robbery. They brought him in on, the whole murder trial or charge, but Michael's lawyer, Mr. Bowen, told him that he was getting a 20-year deal. All he had to do is plead guilty to a robbery. 20-year deal is what they gave the other two co-defendants, and that he would be good to go. But the truth is, Carl knew that Michael was going to get charged with that murder. And all they needed him to do is to plead guilty to the robbery so that they could tie the murder into it and get him a life without parole sentence.
So, and for those who are just now tuning in, we're talking about part two of the Michael Gaines case that took place back in 2003 in Lawton, Oklahoma, where unfortunately a person lost their life. There were, four individuals who were involved with this case. The actual person who was, we'll say, the trigger man who had the gun ended up getting convicted of life without parole. Michael, who did not have a weapon, ended up receiving the same type of sentence. The other two defendants end up receiving a sentence based upon information that they have provided to the police. And my question is, Bree or Melissa, has there been anything that you all has been provided that showed any type of statements that these other two co-defendants provided that allowed them to take a plea deal or lighter sentence?
I believe that the reason why they were able to get a lighter sentence really was based off of the fact that they had paid counsel and the lawyers were well known in the community. I don't believe that and being able to point the finger and getting the story that they needed to set together, setting the narrative and making sure there was someone else that could take the fall. They already had the actual shooter who they found the weapon on, and they just needed someone else to point the finger at so that the two of them could get the deal that they received early on when putting the case together how they wanted it. So they were able to paint the narrative, they were able to give the story the way they wanted it, and they were able to get Michael and the other gentleman in all the trouble they wanted and get away with just 20 years. I don't feel like their lawyers actually felt they were innocent, because if they did, they would have fought to keep them from getting any kind of sentence. They knew they had a responsibility in this, but that because they had the advantage, they utilized them.
Okay. So Melissa, got a question from another person that's listening, who says, so elaborate more on inadequate representation. I'm sorry, I should know more. And obviously, we talked about how Michael was represented at trial. Can you kind of elaborate a little bit more on when we're talking about how he was ineffective, what I call ineffective counsel?
Ineffective counsel. Insufficient defense and effective counsel, same thing. That is also one of the major components that contributes to wrongful convictions. I think the number of wrongful convictions that it actually contributes to is very understated, because it's very hard to prove a Sixth Amendment violation, which is where your right to counsel comes in. And the courts don't really often recognize when somebody has not been adequately represented. I mean, you can have somebody with an attorney who calls no witnesses on their behalf, really doesn't put a defense together. And I've seen cases where the court will call that trial strategy. I don't understand how that's a strategy to represent your client. So it's a very high bar to be able to prove ineffective counsel. But basically, that's where you're claiming that your attorney did not represent you, and that's a problem, because, as I mentioned before, if you don't have that adequate representation at trial, you can go through every other process of in the post-conviction process, but from appeals to habeas petitions to federal habeas petitions, and you cannot bring up that evidence that your attorney failed to introduce.
Yeah. So you brought up we have a Constitution, so supposed to be afforded the right to have a fair and speedy trial, especially a fair trial.
Mm-hmm.
So when you have these rights that are put in place, but you have the courts who say well, this wasn't brought up at the original trial, so now you don't have the right to bring it up at any other additional trials. So, and Keith, you brought this up earlier. How fair is that to anybody who is in the criminal justice system? So when we talk about the court system being fair and the criminal justice system being fair, that's not really being fair. But there's a constitution that says you have that right, or that right is afforded to you, but the court can, and they don't really have to allow that information into court.
To me, that's not fair at all. But
it's not fair, and I think that's why a lot of people, especially people of color, that may not have the means to hire an attorney. When I first got into law enforcement, I didn't understand that. I thought that all lawyers represented their clients equally. But then as you get, stay in law enforcement for a longer time, you start seeing money really does matter, because if you don't have the funds, your court-appointed attorney is not going to go out and bring these special witnesses in, expert witnesses in. They're not going to go out and hire a private investigator, because you're cutting into their profit. Not all are like that, but there are those that it's easy to tell somebody to take a plea because that's less work. And it's just, as I've said, in any court case, when you plea, I don't think your average citizen who may not know their rights, a plea is a conviction. I mean, it doesn't matter if it's a traffic ticket or not. A plea is a conviction, and that's why a lot of times you hear the district attorneys or prosecuting attorneys say, especially during the campaign season, that they have a 92 or 93% conviction rate. Well, 89% of that is plea bargains, and so that's what a lot of prosecuting attorneys and district attorneys see. Hey, if I can get this guy to plea out, I don't have to go to trial, or offer him a plea. I don't have to prepare. I don't have to go to trial, and they feel that's a slam dunk. Not all at all. So let me clarify. I'm not talking about every, because Virgil, we know he doesn't care if you're a police officer or not. He's gonna go after a conviction, but I think he's fair also, because we've seen him also work to. But I think he's fair. We who I'm talking about. But it's amazing how people are depending on someone to help them get their freedom back, or prevent them from going to jail, and they don't work hard. I call it a bootleg lawyer. Somebody who gets paid. They've got a standard fee, and I remember a long time ago, it used to be where you had 2 or 3 lawyers that worked the court-appointed circuit, and so now a lot of places they have it where it's a lottery type deal. But I'm just sitting here listening to this story, and it's breaking my heart. And it's just breaking my heart. That this kid was told, I get 20 years, and then I go in and they hit him with this. This is unreal.
Yeah, it definitely is. So Bree, we've got one of the listeners who asked this question or made a comment. That is considered coercion. Using the death penalty to get a plea is illegal. And Bree, you've kind of talked about how he was coerced or into the situation that he got himself in 2003.
Absolutely.
And so You know, I know on the previous podcast we talked about Michael's family, his mother. I think you had stated that his court-appointed attorney went and talked to his mother to get him to agree to take this plea deal, even though he knew that he didn't commit this crime. That was a conversation that his attorney had with his mother.
Right. They did go and try to get her to get him to plead. Now, she did talk to him. He still didn't agree to the plea with his lawyer after they came and tried to utilize that by using his mom. What they ended up doing is bringing in a guy named Ernest Harper and asked him to talk to him and scare him into taking the plea deal. So when you're saying that he didn't understand what he was getting himself into with taking a plea deal, he absolutely didn't, because he originally wanted to go in and say that he was not guilty and that he would want to go to trial. But they brought Ernest in. So his lawyer really worked against him in every possible way by bringing in a guy who was a felon for I believe he had served on death row in Oklahoma, got off, but he also had a pending murder case in Louisiana. So they brought him on and utilized that to their advantage. Ernest and I did speak once when I was able to find him, and Ernest said that he felt really bad about coming in and doing this to a child, but he had some kind of contract or deal with the OID's office at the time. So he had to do what he had to do, and that was to convince him to go in there. That's what Mr. Bowen wanted, and that's what he did.
Okay. Well, so everybody, we've got, if you can see on the screens, we've got Michael's mother, who is on the podcast, Lois Gaines. We want to definitely thank you for tuning into the show and to give some more perspective about what took place with your son back in 2003. So we definitely want to thank you for being on here. And guys, Ms. Gaines said it's sad to depend on a court-appointed attorney and you know nothing about the law and to be treated this way. She also goes on to say that I was told if Michael did not take the plea, he would get the death penalty. So again, you've got a mother who does not know a lot about the law. You've got a son who is 18 who does not know a lot about the law, what's going on, and the fact that you've got, and this just isn't something that happens in Oklahoma. This happens all across the country where people of color and people who don't have the finance to hire their own attorney go into the criminal justice system, and pretty much that saying that you're at the mercy of the courts, because they know that a lot of district attorneys know that they can get a conviction because you don't have an attorney that is going to fight for you. And this isn't knocking anything against court-appointed attorneys or public defenders, because they do a lot of good work. And as I just said that, I just watched a movie where it was on Netflix, where this young black female attorney was given a case to handle where this lady had murdered her husband, and she wanted to take a plea deal. Well, the other people that worked in this public defender's office asked her, did she ever admit that she committed the crime? And so she said no. So they said, well, how do you know she actually committed the crime? So this movie goes along, and this young lady takes it upon herself to ask questions about what took place. So this lady shared with her what took place, that her husband had pretty much stole all of her money and had brought another woman into her home, had sex with this other woman. And So without her not knowing all this information, this lady was going to go and take this plea deal. Well, at the end of this movie, come to find out that this lady who she thought was a good friend of hers it was this lady's son, and this lady and her son was going around different cities committing these type of crimes against the elderly people. I brought that up to say because you have public defenders who they've got so many cases, so they just want to get inside of a courtroom, get you to take a plea so they can move on to the next person and get that person to take a plea. But even with this situation, like, and this is obviously something that has happened in real life to somebody, to where if they would have taken a plea deal, they would be in prison. But they had an attorney who decided, I'm going to help you, I'm going to fight for you. And at the end of it, she walked away as a free woman. So there's so many cases like this that has happened. And with what Michael's mother is saying is the fact that, hey, if he didn't take this plea, he was going to face the death penalty, and nobody wants to face the death penalty.
There's other states, in some of the research that I've done, other states that practice the death penalty. If you look at life without parole exonerations, and you look at the amount of false confessions that contributed to those wrongful convictions, you can see it. And the states, the majority of the states that have that are states that practice the death penalty. So I did see a comment where, somebody said that's coercion and it's illegal. Yes, it is coercion, but it contributes to a big amount of wrongful convictions, and especially of young offenders. Because if you look life without parole, there's according to the National Registry of Exonerations, about 191 life without parole exonerations, and over 100 of those included false confessions, and about 50 of those included offenders who are 25 and under. So my point being is that the younger you are, the more likely it is that they can coerce a confession from you, because it's just the young mind. You know what I mean? Someone who's under 25, you tell an 18-year-old, you either do this or we're going to execute you. So you have to make the choice of, do I want to take the prison sentence or do I want them to kill me? And even the parents of those young people, they're intimidated as well. Nobody wants to hear that, they're going to execute your 18-year-old child. And they don't know, the legal system to know that, that's coercion, and or they're trying to coerce a false confession. People don't know that.
Yeah.
I'd like to ask Miss Gaines if she's still on. I'd like to ask Miss Gaines, how is Michael? I know earlier Michelle or Bree said that he's hanging in there and he seems to be in good spirit. But I would just like to hear from her, how he's doing and how she's doing, and has she given up hope, or has Michael given up hope on the chances of him coming home soon?
Well, Keith, Mrs. Gaines is definitely still on with us. She just, I just posted a comment. She said he explained to me that there would be 12 white jurors, and they would have said it could have been one of their family members in that house that died. It's when you are supposed to be, when you go to court, you're supposed to be, face a jury, a jury of your peers. And as this crime took place in Lawton, Oklahoma, where the minority population is, probably 7%, if that. And so, the chance of you having people who look like you sitting on that jury is probably not going to happen.
Virgil, hold on a second. I'm reading Miss Gaines. By the way, Miss Gaines said Michael's in good spirits, but I'm reading what she said his attorney told him. He explained to her, told her that he explained to her that there would be 12 white jurors, and they would have, would have said it could have been one of their family members in that house that died.
Yeah.
Oh man, you don't know what, you don't know how those jurors, it's why would you,
Well, you know what?
this guy had no intention on representing that young man.
No, he didn't.
He's his way out, and that's, man, that is sad.
So,
oh my goodness.
So Keith, remember, I brought this up on a previous podcast where we talked about the Anthony Ray Hinton case in Alabama, where the detectives told Anthony Ray Hinton well before they even went to trial that he had several things that was going to convict him. Number one, there was the prosecutor was white. Number two, the judge was white. And number three, it was going to be an all-white jury. And number four, you're going to get the death penalty. So you've got police officers who told Anthony Ray Hinton before he even sat down in the courtroom what was going to happen with him when he got into that courtroom. That's not, police officers, detectives don't have that much power to tell a person that they are investigating for a crime that these are the things that's going to happen to you. So what took place, this sounds very similar to what happened with Anthony Ray Hinton in Alabama as to what happened with Michael Gaines in Lawton, Oklahoma, where you've got an attorney basically saying, hey, if you don't take this plea deal, you've got 12 white jurors, and they're going to look at this as if that was one of their family members who died in that house. What kind of representation, Melissa, is that? I mean, when your attorney is basically saying, hey, this is all I can do for you. I think I lost Melissa. I think I lost your.
Here, I had myself on mute, so I didn't have any interference in the background. I'm sorry.
Okay.
I think that, and I hate to say it this way, but in some of these cases, it appears that the attorneys that were appointed work more for the DAs or the prosecutors than they do for their own clients. I know you said it too, and I'll say it. I know some public defenders who do a great job at what they do. But in these cases, where we see this type of injustice, if you really look at the case, it almost appears that, they maybe perhaps were handpicked just, to have this case go the way that it should have went. And yeah. I know that, that's a big statement to make, but I don't think it's off the mark at all.
But his lawyer did admit to me that he did not have a defense for him. He told me, he said, I did not have a defense prepared for him. I told him to walk in there and take whatever they gave him as a plea, and we would work it out from there.
And again, in these serious sentences, if you're facing, a charge where the death penalty or life without parole can be an option. Now, again, life without parole, they don't have any criteria for the legal counsel that they appoint. These are serious felonies, obviously. And there's really there's only 11 states that have any type of criteria at all. So, they don't have to appoint somebody who's worked a murder trial before. They don't. So, I mean, what kind of representation are they giving these people?
Yeah. Yeah. Hey, Michael Mother had also said that he's in good spirit, and that she also stated that she's a believer that God will work things out. And So, and we've also got some information we want to put up here about where people can find out more about Michael's case. And Bree, I'll let you kind of speak a little bit on that because I know you're involved with some things where people can find out. There's a petition, so you can share with those who are listening a little bit more about how they can find out about more about his case.
He has a website, and it is www.justiceformichael.org. All of my social media accounts are linked to that website along with the petition, but also if they go to Facebook at Free Mike Gaines, I have all of everything posted there as well, the petition and things of that nature, along with his website. So you can pretty much go in between either of those two, and you can find his case and you can find the petition, and they can read up on it and find out more information. Many of people have subscribed to the website, so they're free to subscribe and ask me any questions. I'm open to answer anything that they need, or they can message me on Facebook Messenger, and I can answer any questions that they have from there too.
Okay, good. So, Keith, I want to let everybody know who is watching the podcast now, or who may listen to this podcast at some point later, to know that, people may question, well, why are two men who are in law enforcement, why would you have a podcast show about somebody who was convicted of a crime?
Why wouldn't we? Why wouldn't we?
Well, yeah, why wouldn't we? But at the same time, I want people to know that, this is about people receiving a fair trial. I don't care what race you are, whether you're African American, Native American, Latino, whatever, you deserve to have a fair trial. And we utilize this platform to talk about topics that are real to the public and to families. And so to know that two Black men who are in law enforcement are talking with supporters of Michael Gaines and talking with, his mother, she's also on here. The fact that we know when things are not right, we're going to utilize this platform to talk about those things. So people to know that, the criminal justice is not always right. It's not always right. And I believe that you definitely need to talk about those things when those things do happen.
Well, if we don't, what does that say about our commitment? We took an oath to be fair and equitable. And so, we don't, our main focus is not to judge or to convict anyone. That's what the criminal justice system is about. And if there's some questionable behavior on any level, I think we have to talk about it. Yeah. And, it's amazing that people want us to be one-sided. Well, he's in the penitentiary. You shouldn't show any kind of support. He's paying his debt to society. That's what he got himself into that. Man, when you hear this stuff about, things that weren't allowed in the testimony, weren't allowed in court, that what the lawyer said that he wasn't prepared. You tell someone that we'll offer you 20 years, and then you get in the courtroom and you're told that you got life without parole. I mean, how do you not look into that?
Exactly. Yeah.
Yeah. And so I'm just going to say this. I don't look at it. It doesn't matter to me what people say when it comes to about being fair, and we have a platform, and to the listeners, it wouldn't matter if Michael was African. Not that he's African American. Wouldn't matter if he's white, Hispanic, or whatever. We have a platform that we have to use and that we should use. And I believe we were given this platform to talk about it. We're going to talk about you and the law. we have to hit all aspects of it. We have to hit the good points and the bad points. And so, I'm honored to have this topic on our podcast. But Mama Gaines, we appreciate you too for listening to us, and know our prayers are extended to you and your baby boy.
Yeah. Hey guys, we're coming up on the last few seconds of the podcast, and Melissa and Bree, we definitely want to thank you all once again for coming on and talking about Michael's case. And I know in the coming, I believe next week, there's going to be this meeting that's going to take place with some other people that's going to get together to learn a lot more about Michael Gaines' case and what they can do to help. So, we're definitely going to be in touch, and we're definitely going to follow up and with you all to see where things are at, because I think it's really important to keep a spotlight on Michael Gaines' case and any others that are in the same situation. So again, Melissa and Bree, we thank you all for taking the time to come on. And you ladies have any final things to say before we end the podcast?
For me, thank you guys for having us again, but also I just ask that everyone please take out the time, if they're interested, to please log into that website or log on to any social site that we have and just learn more about Michael's case, because he really was handed an injustice that really does need to be corrected.
Yeah, exactly. Melissa?
I want to say thank you for the opportunity to speak about this, and for using your platform to, bring an injustice like this to light, because I think the more people that pay attention to cases like this, it brings more attention that they happen. People don't like to believe, that people are, wrongfully convicted and in prison, but it does happen, and it happens too much. So thank you for using your platform to bring some attention to that.
Exactly.
Thank you.
And we've got another comment from another listener who says, great, interesting show. So we want to thank you all for tuning in for another episode of You and the Law podcast show. And we want to remind you that you can follow the podcast show on our social media platforms. You can follow us on Facebook at You and the Law One. You can follow us on Instagram. You can also go to Anchor, Spotify, Google Podcasts, and we're now on Apple Podcasts. So you can listen to our rebroadcast shows on all of those platforms. You can also find us on YouTube as well. So go subscribe to those social media platforms to learn more about You and the Law. And you can also listen to all of our previous podcast shows and catch up on some other topics that we've talked about. So to my co-host, Chief Swag,
Man, I told you about that, man. You know what? There's a little bit of levity, man. I've told you about that. I'm not going to remind you anymore, man.
What, man? You are the co-host.
No, I'm the host.
You're the host. Oh.
Yeah. And I'm allowing you to be part of this. So, no, okay. Get it right.
So Melissa and Bree, you've heard the man say he is the host of the show. So, but so next, everybody, we're going to be back on live next Thursday at our original time. Are we going to be back on our original time next Thursday, or are we going to be back on more?
We got one more 7:30.
One more week. Okay. All right.
Central.
So everyone, make sure you tune in next Thursday at 7:30 p.m. Central Standard Time for another episode of You and the Law podcast show. And so we want to thank you all for tuning in and learning more about Michael Gaines' case. And we will see you all next Thursday at 7:30 p.m. on the podcast.